electronically. A different person from the person who rejected your claim in the state disability determination office will review your medical information and make a new decision. You will be given a response in writing. Appealing process continues. The second appeal type is a hearing. You can ask for a request for hearing by an administrative law judge. You must also request to fill out the appeal disability requirements. You can fill these out and mail them in or turn them in online. If you want to meet in person with the judge, you can request this. After meeting with you and discussing your case, the judge will give a decision at a later time in writing. The third appeal type is the Appeals Council review. Fill out the request form review of decision order of the administrative law judge. You cannot submit this anywhere online. You must fill this out on paper and mail it in to the local Social Security office. Someone from the Office of Disability Adjudication and Review will go evaluate your case and notify you by letter of the new decision. The fourth appeal consists of you going to your district court. You need to hire an attorney to file a case against the SSA. A district court judge will hear your case and send you a response through the mail. Lawyers' involvement with disability. Appeals are more often associated with hiring a lawyer than that of an initial file for Social Security. Most cases that are rejected could have had a different outcome if the person who was filing had assistance from an expert. Social Security disability claims fail for a variety of reasons. An application may be missing important information. Medical records may be inappropriate. The case may not be presented clearly. Statistics show that your chances of getting benefits are better if your claim or appeal is done with an attorney. If you choose to hire an attorney, most cases are handled on grounds of contingency. This means that the attorney is paid only if the case is won. An attorney's fee is usually 25% of any past due amount the Social Security office gives on your behalf. Frequently asked questions. How is the disability determination made? The SSA disability evaluation is made under a procedure known as a sequential evaluation. For adults, this process requires strict and constant evaluation of your current work activity, the severity of your impairment, your physical and mental disability despite the disability, your work history, your age, and education level. For children applying for SSI, the process requires sequential review of the child's current work activity, the seriousness of his or her impairment, and an assessment of whether the impairment results in a serious functional limitation. 2. Once your claim is accepted, how long does it take to receive the benefit? SSDI recipients may be entitled to past benefits if the SSA finds they were disabled before their application date. Actual payments cannot be made until 5 months after the date of the pronounced disability. Cash benefits payments cannot be paid retroactively to cover more than 12 months before the application date, no matter how severe your disability. There are exceptions to the 5-month waiting period requirement. Disability payments may begin as early as the first day of the month after an individual files an application, but will not happen no time before the first. Furthermore, you may be found presumptively disabled and receive cash payments for up to 6 months while the formal disability determination is made. The agency must know for sure that one is disabled by proof of medical examinations and documentation. Frequently asked questions continue. 3. Can I receive disability benefits or payments while getting Medicare or Medicaid coverage? Yes, you may. Medicaid and Medicare are America's largest health insurance programs. People receive SSI benefits, and other people with low incomes qualify for Medicaid, while Medicare support is only obtained through working in jobs covered by Social Security, the Railroad Retirement Act, or for the federal government. Some people even qualify for both. If you receive Medicare or Medicaid along with your disability benefits, you do not have to write in any letters or fill out any more forms. If you qualify for such the federal support, the government will send you all of the necessities. SSDI recipients qualify for Medicare. The coverage does not start for 2 years from the onset of disability, and that means 2 years starting after the initial 5-month waiting period. This is crucial information because you may not have medical insurance coverage for several years if you do not have some form of medical aid or are not poor enough to qualify for SSI Medicaid support. There are 3 exceptions to the 2-year rule. If you have end-stage renal disease with kidney failure and you require dialysis or a kidney transplant, coverage by Medicare can start the 3rd month after the month in which dialysis began. If you are terminally ill with a life expectancy of 6 months or less and receive hospital care, assistance by Medicare can begin immediately. Also, individuals with amyotrophic lateral sclerosis will receive Medicare as soon as they qualify for benefits. Thank you for watching. By American Advantage Law Group Inc. Address 3848 Campus Drive, Newport Beach, zip code 22660. Phone number 949-863-1888. Fax number 949-863-1888. You may visit us on web at www.americanadvantagelawgroup.com. Thank you for watching once again. Goodbye.